Okay, so here's an interesting one then. There's some relief in sight, perhaps, for the Gauteng High Court's overwhelming caseload crisis. Now, the Gauteng Division of the High Court has confirmed the introduction of mandatory mediation in all civil trials as of next month. In a statement, the Office of the province's Judge President says there's a delay of up to 7 years for trial dates. To help us understand what this means and if it will really help with the backlog crisis, joined by Advocate Justin Erasmus, the CEO of the Personal Injury Plaintiff Lawyers Association. Advocate, thank you so much for the time. Appreciate it this morning. Won't you just help us get perhaps clearer detail with regards to what is this delay about, where does it come from, and why do we have such a big one?
All right, good afternoon. And let me first just say thank you for having me. It's great to be on your show. The sources of the delay is quite simply that we don't have enough judges. It's as simple as that. The judiciary is under-resourced. There are not enough courtrooms, there are not enough registrars, there's not enough judges, and matters are just not getting heard. So they stand in the queue. The queue is running now at 2031.
2031 is a very long time, ultimately no judges. Are we saying then that the best solution in a case like this is for mediation? Is that really the right way to look at it? Or is it a case of also needing just to put forward more judges?
My view is that the root cause of the problem is the lack of judges. It will help to an extent with mediation, but what has not been carefully considered in this directive, and we are very, very concerned about this directive, is that it's going to cause massive prejudice to plaintiffs who have matters on the roll now. Let me perhaps, if I may explain that, you'll see what I mean.
Please, yeah.
Johannesburg and Johannesburg and Pretoria have together about 300 matters a week on the trial roll. From June of this year, so the start of the second term, you will retain your trial date if you can get a certificate of mediation from having completed a mediation with the Road Accident Fund or whoever, it's mostly the Road Accident Fund. It's not going to be easy to get a certificate of mediation from them. The Road Accident Fund has got a long history of not cooperating with that sort of thing. If the Road Accident Fund doesn't give you a certificate of mediation, and we are fairly certain that in the vast majorities of cases that they won't give you a certificate of, there won't be a certificate of successful mediation, you will have to go through a whole process of serving notices and eventually getting a compelling order which will go nowhere. And then your relief would be to set the matter down in 2031. You've got to put it on the default judgment roll. So you're back to 2031. So it's not been thought out properly. Remember, mediation is an unproven concept. We don't know to what extent it's going to work. We don't know to what extent the defendants, and particularly the Road Accident Fund, will come to the party. We don't know to what extent, for example, the Road Accident Fund has the capacity to mediate on a large scale. Remember, they're an organization with about 2,000 people nationally. That's including from the cleaners to the CEO. Somehow they're going to have to find the staff to mediate over 300 matters a week just in Johannesburg and Pretoria.
Wow.
So what that means, and let me give you a practical example. Most of the matters that are on the roll now, which are going to be kicked off the roll because they can't comply with something that is impossible to comply with, started their action in 2020, 2019, 2020, usually. They then jumped through about 2 years of hoops because in 2019, the judiciary made new practice directives that made it quite hard to get to court. But those plaintiffs jumped through those hoops, they persevered, and in about 2022, they would have applied for a trial date. They would have been given a trial date in the second half of 2025 or early 2026. So the attorneys are now going to have to go back to their client, and we're going to have to say, sorry, we did everything that we possibly could, everything that was asked of us.
Wow.
You've waited for 3 years, but that 3 years is in vain, because you know what? There's a very good chance you're going to wait another 2, 3, 4, 5 years to get back into court because there's this directive that is impossible to comply with.
So what's the better solution here in your mind then, Advocate Erasmus? What is the right solution or the best possible solution given the circumstances?
Well, it's twofold. You've got to deal with the root cause, which is quite simply not enough judges. Mediation is a very good possible second leg to go with, but it needs to be phased in properly. You know, the judges started talking about mediation and trying to introduce this idea over a year ago. Suddenly, it's brought out last week, and it's going to be implemented in a week or two's time. We think that what they should do the first year, you should retain your trial date. You should have to try and mediate. You should do your best to mediate, and the trial judge should have to convince the trial judge that you made a bona fide effort to comply with the directive and to mediate. That alone should get rid of some matters, because there will be some mediation. But if through no fault of your own, you couldn't comply with the directive, and there'll be thousands that tried their best but couldn't, you should retain your trial date. And then we'll see where we go over the next year. We'll see exactly how the directive needs to be tweaked. And then perhaps from June next year, it could be compulsory. We're not saying to the judiciary, we don't want to mediate. We just want to say, don't bring it in with a guillotine that's going to prejudice hundreds of clients every week into losing their trial dates after they've waited nearly 5 years for that trial date already. And that's really our solution. It's go deal with the root cause, and then this mediation has a possibility of dealing with some of the symptoms of those root causes, but it has to be dealt with properly, and it has to be dealt with in a way that's sensitive to the rights of the existing rights of litigants who are before the court.
Yeah, it just seems like very, very tough to kind of get a clear stance here. And as you said, then phasing it in perhaps would have actually been the right way to deal with it, as opposed to almost just throwing it into the mix. Advocate, we appreciate the time. Thank you so much for that update. Also, your clear thoughts on this as well. I think a bit of education as well for all of us with regards to this then, and how much delay it could actually cause further down the line as well then here. Is this a good thing? Well, it's going to be very interesting, because Justice Minister Mamoloko Kubai has said that the framework for using the mediation to settle these disputes is under massive consideration. And ultimately, they want to put it forward next month. Will that come to bear? We'll certainly see.